S15A 1407, Lamar Gates versus the state. Saraliene Durrett for appellant, Deborah Wellborn for appellee.
May proceed when ready.
Mr. Chief Justice, and may it please the court. My name is Saraliene Durrett. I represent appellant Lamar Gates in this case. At issue today is the misapplication of Rule 404B by the trial court, by the prosecution, and by defense counsel. The facts of the case are very straightforward. My client is alleged to have murdered Anthony Wilson in broad daylight in front of the apartment complex where both my client and Mr. Wilson lived. The murder weapon was alleged to be a 9mm handgun. The evidence at trial came out that way, that the shell casings were all from the same type of gun, which was a 9mm handgun. Despite the fact that no murder weapon was found, the state elicited testimony from 5 different witnesses that my client allegedly possessed firearms in the days and weeks leading up to the shooting, and that an unrelated firearm was found in the truck where he had previously been riding after he was arrested. This evidence came in without proper notice from the state. It came in without a proper purpose under 404B. The trial court did no 404B analysis of this evidence, and there was no limiting instruction that explained to the jury how this evidence should have been used. As a result, the jury was left to wade through this unrelated evidence to determine what was relevant and what was not. And the jury was also invited to convict my client based on the fact that he had the propensity to commit these crimes and that he was a convicted felon. I'd like to focus on 3 points, really. The first, the admission of this evidence without a proper 404B analysis was plain error. Second, the use of this evidence in the prosecutor's closing argument to argue that Mr. Gates had the propensity to commit the crimes charged was misconduct. And third, the failure by trial counsel to object to or prevent the jury from hearing this evidence constituted ineffective assistance of counsel. As a result of these errors, the entire process from the beginning of the case until the end of the case, and I would argue still today, was an unfair process. It was a broken process for Mr. Gates. His right to a fair trial was completely disregarded by the state. There was no guardian there to protect him. The trial court did nothing when this evidence came in, and defense counsel sat idly by as these arguments were made that my client was a bad person and therefore must have committed these crimes. Moving to the 404B evidence. The trial court made no findings at trial regarding 404B evidence, and the order that it issued denying my motion for a new trial is an incomplete analysis of 404B at best. The court states that it found the evidence to be relevant. It stated that the evidence was relevant to prove intent, motive, preparation, and that Mr. Gates had access to firearms. However, the court found that no notice was required, and I will submit to this court that you cannot have it both ways. You cannot offer this evidence for intent, motive, preparation, and to show that the defendant has access to firearms and not also comply with the notice requirement of the rule. You just can't do it that way.
Let me ask you this. He was charged also with possession of a firearm by a convicted felon. Wouldn't that evidence of the other gun be admissible for purposes of that charge?
Well, Your Honor, I think there are two answers to that question. The first is, if it were going to be admitted for that purpose, there should have been a limiting instruction that instructed the jury, this evidence is coming in, you cannot consider it for the purpose of deciding whether Mr. Gates committed a murder. It's solely for the purpose of determining whether he
But
possessed a
at that point,
firearm.
we have a different issue. We don't have an admissibility issue. We have issue about whether there should have been a limiting instruction.
No, Your Honor, I still think you have a very clear admissibility issue. The state gave no notice that it was going to be bringing this evidence in.
What notice would you need to bring if it's directly related to the charge?
It actually, Your Honor, it would be sought, I think under your scenario, it's sought for the purpose of showing intent, correct? The intent to possess the firearm?
Well, yeah, okay.
And under Rule 404B, if you're going to offer something to show intent, you need to give notice prior to trial so that trial counsel is aware that it's going to be coming in.
It's definitely relevant, but then the other issue would be a notice issue.
The other issue is a notice issue. Everything in 404B, did the act actually occur? Has it been shown by a preponderance of the evidence that the act actually occurred? And I'll get into that in a second. I think it's not. And there's a clear 403 balancing issue, which this court in Jones said becomes particularly important in a case like this. You can't just disregard the question of whether the probative value of that evidence is substantially outweighed by its prejudicial nature. And I will submit cases like Hernandez from the 11th Circuit says, when intent is not an issue in a case, or when the state has a strong issue or a strong case on the issue of intent, the marginal value of that probative evidence is quickly outweighed by its prejudicial nature.
Did your client at trial say anything about the fact that the state had not found the murder weapon and that the defendant was not tied to the murder weapon?
I believe that there was an argument that the gun, there was a .45 caliber handgun that was admitted into evidence, and I believe there was an argument by defense counsel, hey, this is not the murder weapon. So it was kind of an alert to the jury, this gun's coming into evidence, but it's not the murder weapon. And I think that's the closest we get. And one of the issues that I raised here, again, is the ineffective assistance of counsel, and I think that's part of the issue, is that there was counsel sitting idly by, basically on autopilot, letting this evidence come in, overwhelming evidence, without actually standing up and making an argument.
Why is it not strategic on the ground that you could have asked for notice, but he clearly wasn't surprised by any of these charges? They were all in the discovery, right?
That's correct, Your Honor.
So notice is nice and you can ask for a hearing, but you don't have to ask for a hearing where it quite obviously is relevant, at least to the felon in possession charge.
Well, Your Honor, I think I'd like to break that down a little bit. It's not incumbent on the defense to ask for notice of 404B. It is incumbent.
But it's incumbent on you raising it as ineffective assistance or as plain error to show that it would have made a difference to ask for notice.
And I do think, Your Honor, that had notice been requested, as defense counsel stated at the motion for new trial, had he been notified that it was coming in, he would have asked for a hearing, and the court then would have been forced to make the 404B analysis that I'm asking this court to make.
Right. The problem, though, is, okay, so then the court would have had to make the analysis. Well, the first part of the analysis, whether it's relevant to an issue at trial, it sounds like you've conceded, as you probably need to, that it's at least relevant to the felon in possession charge, right?
I do think, Your Honor, that the argument could be made that it is relevant to that intent. But as I said, I think there are cases out there that say it's quickly outweighed in the 404B balancing test.
Well, the second issue then would be, can you show harm by the fact the trial court didn't do a 403 balancing before trial when the court does not have to explicitly do a 403 balancing unless it's asked to. It's assumed the court followed the law. And the court did that balancing in the motion for new trial, at least implicitly, and ruled against you. And under the same case as you were citing, we give very broad discretion to trial courts on the 403. So how do you prove harm from the lack of getting a 403 balance before trial?
Well, I think you can prove harm in several ways in this case, Your Honor. I've raised this issue both as under the plain error standard and also as ineffective assistance of counsel. I recognize that both of those standards are difficult standards to meet. And under the plain error standard, the error has to be an error, it has to be plain, it has to affect a defendant's substantial rights, which I think in this case it affected the right to a fair trial. And then, if the court finds that those factors are met, it determines whether it affected the fairness and the integrity of the proceeding. In this case, had the evidence not come in, this is what the state's case would have looked like.
But that's not the question about, you have to show that it shouldn't have come in.
That's right, Your Honor.
And I don't see how your argument about notice or 403 or 404B generally help you. The only thing I can see is you didn't get a limiting instruction.
That's correct, Your Honor, but I also think if you go back to the 404B analysis, there is an issue there to cut the issue so closely and to say we can admit it in a murder case for the purposes of showing that he possessed a firearm on this occasion. I think it slices that rule a little too thinly. In this case, there is no allegation that Mr. Gates possessed a firearm on November 30th at the Laurel Mill Apartments without actually possessing the intent to kill Mr. Wilson. And so I think by backdooring this evidence in and saying, oh, we're now using it to show that he intended to possess a firearm, it ignores the fact that what it was actually used to show was that he killed Mr. Wilson, and that's the intent.
Was the malice murder predicated on the shooting with a gun?
Your Honor, there was a malice murder charge. There were 2 felony murder charges.
Right. Was the malice murder predicated on shooting with a gun?
Yes.
And was the felony murder and aggravated assault predicated on the use of a deadly weapon?
Yes.
So the state had the obligation to prove that your client actually was in possession of putting aside the felon in possession, that your client was in possession of a handgun at the time of the crimes.
Right, Your Honor, and I don't think that there's any doubt that the person who killed Mr. Wilson with the handgun intended to possess that handgun or intended to kill him. I don't think that's a doubt. I don't think there's a doubt about that.
Did your client offer to stipulate that if you could prove his identity, that he possessed a gun?
He didn't, Your Honor, and I know that there are case laws that exist, that say that's a possibility, and I will then refer the court back to the ineffective assistance of counsel claim, where counsel did nothing. Counsel heard this evidence was coming in opening statements. Counsel heard various witnesses testify about this evidence and did nothing. Counsel saw that the .45 caliber handgun that has no relationship to this case was going to be admitted into evidence along with its magazine, and counsel did nothing. During closing argument, counsel stood up, and he is the only person in the entire trial that places the 9mm handgun in my client's hands. His own attorney did that. No witness said that he did that, but his own attorney stood up and said, let me just give you a list of the guns he might have possessed prior to this shooting. He names 5 or 6 guns, including a 9mm handgun. And finally, trial counsel did nothing to object during the rebuttal argument of the state, in which they argued a straight propensity argument. So even as if the court is suggesting that it was proper to admit this for the purpose of showing intent to possess a handgun, that is not how it was used in closing argument. In closing argument, the prosecutor said, is it believable that this person sitting over there would possess the 9mm handgun on that day? Yes. And you know why? Because he was found with a loaded handgun. And he made sure that they talked about the fact that the gun that was found at arrest was loaded. He also, prosecutor repeatedly said, this is a convicted felon. He cannot possess a handgun. This is a convicted felon that was found with a gun at the time of his arrest. And I would submit to the court that there are cases out there, there's a Third Circuit case, Moore, in which the court talks about the overwhelming inflammatory and irrelevant evidence that comes flooding into the trial in that case. And the court says,
why is that even irrelevant? If he's, which gun, as a felon in possession, was he charged with possessing the murder weapon or?
The murder weapon.
Okay, so that weapon's not there. The state has to prove beyond a reasonable doubt that he possessed a weapon. The fact that he possessed weapons before and after the fact is extremely relevant under our case law and federal case law to the fact that he also possessed a weapon on that date.
Your Honor, I would say that the state has the burden of showing that he possessed the 9mm handgun. And I think there's a difference here. I think telling the jury that he possessed handguns prior to this shooting and after this shooting definitely begs the jury to convict based on a propensity argument.
That's the whole point of 404B evidence. They didn't say in a case involving no guns at all, like a rape case, they didn't say he's a bad guy, he possesses a lot of weapons. They said in a case where they had to prove beyond a reasonable doubt something that they could not directly show the jury. They had to circumstantially show he possessed a gun. They had to prove that. And 404B, the purpose of 404B is to allow the state to show conduct before and after that is similar in intent.
I understand that, Your Honor. Again, I would go back to the fact that there was no notice in this case. There was no 403 balancing test. And I know that you've stated that the trial court performed that test in its motion for new trial order. It actually did not. It does not mention 403 anywhere in that order. And I think the problem is, I will refer this case, the court, to its own recent case in Jones, where it says that 403 balancing test becomes particularly important in a case like this. And I think the danger here, and the danger that the United States Supreme Court has recognized and that this court recognizes, is that when this evidence comes in and it's argued to show that this person acted the same way on this day, that he acted on a prior day, that we have a problem. We're begging the jury to convict him because he is a bad person. I will refer the court to a Court of Appeals case, Harris, State versus Harris from 2011, in which the court talks about the fact that there was no limiting instruction provided to the jury when evidence of a defendant's prior criminal conviction came in. That criminal conviction was the only piece of evidence that went back with the jury at the time of deliberations, and the court said the jury was basically a captive audience.
What was the charge in Harris that the defendant was facing?
I believe it was a gun charge, Your Honor.
And what was the prior offense?
I believe it was also a gun charge, Your Honor. And I think the problem is, in that case, they were saying the jury is a captive audience to that evidence. When it comes back in with the jury is a captive audience. They are staring down that evidence, and they are left with no choice but to think this person is a bad person and we should convict for that particular reason. And I think that I think that's the issue here, Your Honor. And even if the court determines that it was relevant to intent, I think there wasn't a proper 404B balancing test, and I think the jury was explicitly asked to convict based on propensity. And with that, if there are no other questions, I'll reserve the rest of my time.
Thank you. Ms. Welborn?
Thank you, Chief Justice. Debbie Wellborn. I'm here on behalf of the state of Georgia, DeKalb County, and Robert James, and may it please the court. The state contends in this case that, to give you a little bit of background about this case very briefly, it's a malice murder case. The day before the shooting, the victim sent a picture of his genitals to the appellant's girlfriend. Her name is Mrs. Perticari. He sent it to her on her cell phone with a message that basically said, if you're ever lonely, call me, something to that effect. That night, that very night, the appellant told a neighbor, Mr. Perry, about the pictures that Mr. Wilson had sent his girlfriend, and he made a threat in the form of he was going to have to see about him. The next day, appellant's leaving his apartment, following his girlfriend, Mrs. Perticari, out of the apartment where she was taking her dog for a walk. She happens to run into Mr. Wilson, sees him, and speaking to him. Appellant pulls out a gun and he shoots Mr. Wilson numerous times. He also struck the vehicle when Mr. Wilson was there talking with a Jakara Smith who had stopped by with a friend of hers, John, to get something to smoke. Apparently, Mr. Wilson, the victim in this case, sold marijuana in the neighborhood, in the parking apartment complex. Mrs. Smith, who was present there, actually identified appellant as the shooter in a photo lineup that evening. And then Latrice Wheeling, who is actually Mr. Perry's wife, She was in her apartment at the time of the shooting, heard the start of the gunshots, looked out her window. She actually knew the appellant, and she got up, saw who it was. She actually physically saw him shooting, saw the victim go down, and she saw the appellant put the gun in his pants, walk to his green truck, and leave the scene. There were numerous witnesses who saw appellant leave the scene in that green truck, which was known to be his truck, or that he drove frequently, and that was immediately after the gunshots. 4 days later, the fugitive squad located appellant, and he was in that same green truck. They took him into custody. A loaded handgun was on the seat next to him, and a search of the vehicle pursuant to a subsequent search warrant revealed several items, including a black fitted beanie cap, which had been identified by several witnesses as the shooter having been wearing that. With regard to the enumerations of error, the state contends that this is not a 404B case. And the reason why is we're talking about evidence of Mr. Make sure I get his name right. Mr. Perry testified that he was a friend of the appellant's, and that appellant showed him guns on various occasions that he would buy and sell. And that was part of the evidence that the state used to show. And in fact, one instance, both Mr. Perry and his wife, just the Sunday before the shooting, said that he had shown them another gun. There was no
I don't understand how you make the argument that at least some of this evidence was not intrinsic to the crimes.
Intrinsic?
What was not, oh, I'm sorry, extrinsic.
Okay.
That it fell under 404B.
And the reason why I say that, Your Honor, is because we're not talking about a prior, the only thing criminal about possessing and the guns, buying and selling them, was the fact that he was a convicted felon. And I understand that's one of the counts.
That makes it a crime and a bad act. But even if it wasn't a bad act, it's other act evidence, good or bad. You have to show, if it potentially could be bad character, you have to show that it's either intrinsic or that it qualifies under 404B.
And we contend it's intrinsic. And the reason being is that in order for him to carry out the crimes charged in this case, the state had to put a gun in his hand. The state had to show that he had access to a gun. And we're talking about a gun that he then used, and it was all part of the story. He gets this call, sees this text message that had been sent to his girlfriend.
When you say you have to put a gun, if you could put the murder weapon in his hand even a month earlier, or maybe even a gun similar to the murder weapon you couldn't prove was a murder weapon, you might argue that it was intrinsic, that you're showing he had that to show that he continued to have it. But you're showing that he had some other gun. Now, it might be relevant to show he has the intent to possess a gun, but I don't see how it is at all relevant to show that he had the murder weapon either before or after the crime.
And I'm not proposing that. I'm saying there is not any evidence that he had the murder weapon, because the murder weapon was never found.
Right.
There's no way of connecting him with so the state had the burden of putting a gun in his hand. And the only evidence that they had was the fact that he had. And keep in mind,
that he
Your
had
Honor,
other guns. Let me ask you, also had the burden of showing that he had intentionally killed the victim. Had he intentionally killed another victim in an unrelated incident a week earlier, and also 4 days later when you arrested him, he had intentionally killed someone with no even arguable connection to this crime, would you argue that those were intrinsic because it's all part of the same thing, or you had to show his killing people?
No, and that's where the distinction gets in my mind. And obviously it's for you all to decide this, but had the evidence been that he had guns and he had used them, he had threatened, he had used them, he had put them to use, the evidence was harmless in the form of he just would show me guns and ammunition that he would get. There was never any threat. There was never, excuse me. There was never any evidence that any of those guns had ever been used by the defendant, by appellant.
But your trial prosecutor argued that it was bad for him, it was actually illegal for him to possess those guns. So the argument that this was just neutral, kind of, oh, he had a gun and there's nothing wrong with that, your prosecutor argued in closing that he couldn't have those guns because it is illegal to have those guns. And by the way, it's the same illegality that we're charging him with here.
And I understand. The point is, Your Honor, we're talking about having to prove malice murder as well as the other charges, which does include possession of a firearm by a convicted felon. And that is the only reason that it was illegal, was the fact that he had a prior conviction. And the state contends that it's all part of the story of how this came to be, because we're talking about revenge. We're talking about somebody who gets his girlfriend is sent a highly inappropriate text message along with a picture. And most men would be upset if they had seen this coming to their girlfriend's cell phone. Okay. He then, the next day, he sees this victim in this case, and he sees him talking to his girlfriend.
I get all that. I tend to believe this is similar transaction evidence, 404 evidence. My question then is, some of the arguments that the state made about the possession of this firearm probably went beyond what was necessary to show that he had a gun, especially for purposes of the possession charge. So I'm more concerned about lack of a limiting instruction or request for a limiting instruction, given some of the arguments that the state raised. Can you address that?
Yes, Your Honor.
Because arguably the state took advantage of a lack of a limiting instruction.
Oh, as to the use of the evidence and how it could be used.
Especially at closing.
Your Honor, as to the closing argument, let me start there and I'll get back. I will answer your questions. The closing argument, the evidence that the prosecutor argued was evidence that was brought out in trial. And as you know, a prosecutor has we're talking about, they are claiming.
Got that, because the reason it's brought in is because it was allowed in. So the question is, should it have been limited to avoid any unnecessary or unfair arguments related to the evidence that was brought in?
Okay, I understand what you're saying, and I think in this case, Your Honor, by virtue of the fact that we have had the only charge been possession of a firearm by a convicted felon, then I think maybe, there might be more of an argument, but I think we're talking about having to prove malice murder. And I think the judge gave the jury the instructions. The jury was instructed by the trial court judge, you have to find the defendant guilty of everything as alleged in the indictment. And they had the indictment back with them. The indictment said that he had to have a 9mm handgun. He had to use that gun on that particular day.
Let me say it this way. I don't mind, it makes sense to me that you can show possession by showing that the defendant possessed a gun at another time. I'm not sure you can show murder by showing that a defendant possessed a gun at another time. And it looks like some of the arguments raised by the state went to show that the defendant committed murder by virtue of the fact that at another time he had possessed a gun.
I respectfully disagree. If you look at the closing argument, he says, would it be unusual for him to have a gun in order to be able to carry it out? I think that's markedly different than saying because he has a gun, he's more likely to shoot. Had we had a prior case where he'd actually used a gun, I would agree with you. But we're talking about all we're talking about is that he had a handgun that he would, or on a regular basis. He was also found with a loaded handgun in his vehicle, which the courts have, this court and the 11th Circuit has clearly found that evidence to be able to come in as relevant and probative. And in this case, I think the fact that we don't have the use of that gun makes it different. If you look at the prosecutor's closing argument, the prosecutor's closing argument said, you know, is it unusual to think because he had access to these guns that he didn't have access to one to use to commit this crime? That's not saying he had guns, so is it how would you say it would be unusual for him to use that gun? He's not saying. In fact, the prosecutor, at no time did the prosecutor argue he never argued that the possession of the guns proved propensity to use the weapon or argue appellant's propensity for future dangerousness.
Did the state present evidence at trial about pressure necessary to pull a trigger on 9mm versus a .45 caliber? Was that part of the record as well?
There was evidence as to how much pressure it takes for a semi-automatic, both guns that were, the gun that was admitted into evidence and the 9mm, there was expert evidence that they both are semi-automatic handguns. And there was evidence as to how much pressure it would take to, I guess, to pull the trigger on that gun.
What is the relevance? What is the relevance of evidence about the trigger pull on the .45?
The fact that it was connected and said that basically it was the same as a 9mm because they were both semi-automatic. It was used in conjunction with, and because they were both semi-automatic handguns, and therefore it was relevant because it was consistent. That's my understanding of the reading. I do not profess to be an expert in firearms, but my reading of the transcript and the testimony that was. And I also have to remind the court too that we did have at the motion for new trial hearing, the defense attorney in this case had been practicing for over 11 years, had more than 40 criminal trials. The judge in this case, who's been on the bench for a significant length of time, Judge Hunter, and the prosecutor in this case, not a single one of them looked at this and saw it as 404B evidence.
Yeah, you're in a new world, though, because until a couple years ago, we had a very broad and loosey-goosey definition of res gestae. But under the federal case law, which I don't think you cite regarding this issue, I don't see how you can say at least some of this evidence falls under 404B. And that as a question is, do you think prosecutors around the state are proceeding on the assumption that evidence like this, they don't need to provide notice and go through the 404B process?
Your Honor, I've read a significant number of cases in the 11th Circuit on 404B versus intrinsic and extrinsic, and pulled a lot of cases. And what I have found, and I'm not saying it's necessarily encompasses everything, but what I have found is when you see 404B, the trigger point for most 404B analysis is being done prior to trial happens to be a prior conviction, or at least a prior arrest or a prior charge, something that has been brought against a defendant by authorities. And I see that, and if you look at that's what most of the cases are talking about. If you look at the cases involving intrinsic evidence, most of those are just a pattern, a way of conducting themselves, how they conduct their business, how they conduct their lives, what is part of their lives that is, and obviously it has to relate to the charged crimes. We're not talking about how they relate to, their personal lives and stuff. I'm talking about things that would be relevant. And I think we all agree that the evidence in this case was relevant. So I think in this instance, that's where I see most of the cases where it needs to be distinguished between. Obviously, There is not I have not been able to find, I don't believe there is one, a case where this court, since the passage of the Georgia Evidence Code, has really discussed what the difference between intrinsic and extrinsic evidence.
One thing we've said clearly is it's called other act evidence, right?
True.
We used to call it similar transaction or sometimes other bad acts. But as we've said, and the 11th Circuit has said very clearly, it's just evidence that otherwise the jury might look badly at the defendant about. And particularly where the defendant is a convicted felon and you tell the jury in closing it's illegal for him to possess any guns because he's a convicted felon, the argument that the jury might have thought nothing about this guy having guns, I mean, I don't understand that.
Yeah, I think though you're talking about though the possession of a firearm by a convicted felon as being one of the charges, and as the gun that was found in the car at the time.
That's a 404B argument now.
Okay, then getting back to Justice, I believe it was Justice Melton's question, under 404B, your concern was the instruction. And in this case, we're talking about, number one, we're talking about plain error. And number two, and we have a lot of evidence in this case. We have 2 eyewitnesses who actually saw the shooter, saw who he was, identified him, and we clearly have motive by the virtue of the information that came in on the text message and the picture.
So why does the state push the envelope? You've got overwhelming evidence.
Push the envelope at trial?
Yes, as far as the gun is concerned, and closing argument.
I think, Your Honor, part of our burden was we had to put a gun in his hand. We had to show that he had a gun and that he could have committed this crime. You can't ever presume what a jury, and I'll be honest with you, in DeKalb County, you never know how things are going to come out. You have to present the strongest case that you have. And I don't think you can, I think we have to put everything out there, and I don't think our prosecutors should limit what they put out thinking that, oh, this is overwhelming. Obviously, it was not so overwhelming that a defendant took a plea, admitted to doing the crimes. We don't have an admission. He went to trial. His trial defense was, it wasn't me. The state had to prove, yes, it was you. And therefore, we had that burden. And I believe that that was something we had to be able to prove in this case. I also note that the defense attorney at motion for new trial made the strategic decision. He said he was not objecting to the gun that was admitted into court, that was used, because he used that as part of his trial strategy to distinguish it, and said that the police officers were just jumping to the first person they came to. Unless there's further questions, the state respectfully requests that the conviction be affirmed. Thank you.
Thank you. Any rebuttal?
Yes, sir. I'll just touch on a few things briefly. I know I spoke about the Harris case, which was the Court of Appeals case. I'll give the cite on that case.
Is that in your brief?
It is not actually in my brief, Your Honor.
How about sending the clerk a short paragraphing that?
Thank you, Your Honor. And
short letter in a paragraph.
Thank you, Your Honor. And I'll just note.
Give the other side 5 days to respond after you have 5 days to do that.
Thank you, Your Honor, and I'll just note that the charge in that case was possession of a firearm by a convicted felon. Prior conviction went back. I think it was actually a drug conviction in that case. That was the only evidence that went back with the jury. There was no limiting instruction, and the court said the jury was a captive audience, and they were constantly reminded that he was a convicted felon and a bad person with a propensity to commit crime. So I just wanted to correct that record. I just want to respond to a few things that the counsel for the state stated. She finished her argument by talking about the strategic decisions by trial counsel not to object to this evidence. And I just want to highlight a few things that trial counsel said during the motion for new trial. When asked why he did not object to the officer testimony about the trigger pull or the weight of the .45, he said, I didn't understand why they were putting it in. I thought they were trying to distract the jury. I thought they were trying to mislead the jury. I think that shows a clear misunderstanding of Rule 404B and Rule 403. And I think that the standard under Strickland is one of objective reasonableness, not of whether this particular attorney thought this was a sound trial strategy. It's whether it was an objectively sound trial strategy. Why didn't you object to the magazine being admitted? I didn't even think about it. Why didn't you try to limit the evidence regarding the arrest? It didn't cross my mind. Why didn't you point out that Latrice Perry had never previously said that she saw the appellant or the defendant with a firearm? I missed that. Why didn't you object to closing argument? No reason. All of these things, I think, go to show that there was a complete lack of understanding by trial counsel as to how this evidence could have been used to shield his client, how the rule could have been used to shield his client. And there was a complete abdication of his duty to his client. As far as the actual requirements of 404B, it sounds like that's where the court may be focusing its attention rather than on the intrinsic evidence issue. There are other requirements under 404B. There is the notice requirement. There is proof that this is relevant to something other than character, and it sounds like at least some of you believe it's relevant to show intent to possess the firearm. The third requirement there is that you have to show by a preponderance of the evidence that these other acts actually occurred. And I think there is a real problem when we get to that factor as well. The state stood up and said that the firearm that was found at the time Mr. Gates was arrested was on the seat next to him. There is no evidence of that. The evidence was he was arrested. They took him out of the pickup truck he had been riding in. Somewhere in that truck, they found a firearm. The firearm was all rusted out. One officer got up and testified about the weight of that firearm, particularly when it was loaded, the trigger pull of that firearm. There was no testimony about the distinction of the trigger pull between a 9mm and a .45. The entire amount of that evidence was about the pull of that .45, how to fire that .45. And it was reiterated that that gun was loaded when it was found. And I think that that really set the stage for the jury to convict on propensity. So you have that preponderance of the evidence standard. I think they can't prove he was in possession of the firearm at the time he was arrested. And I think that's why they didn't charge him with it. And I'll conclude there. Thank you.
Thank you very much for your argument, both sides, and be safe as you journey home. We'll stand at ease till 2 p.m.